Oh, ladies and gentlemen, David reminded me. Ladies and gentlemen, good morning. Welcome to Young at Heart. What could be better than having somebody else cook for us and clean up after us? And we're going to learn a few things and we're going to be entertained. And you get to fellowship with your friends and family right here. So welcome this morning. I wanted to tell you the birthdays in June. Pat Reed was the 5th, and Pat is at home. And, she's been sick. Well, she hurt herself and went to rehab, but she is at home now, and she said that she would appreciate a few phone calls. So if you've got Pat's number, give her a call. If you don't, holler at Kristen, and she can get you that number, and just give her a call, or even maybe just a card. That would just let her reach out and let her know that we care about her, because she is a very important part of this church. Also, Barbara Jean Cronenberg's birthday, she's back in the kitchen, is the 23rd of this month. And the last one that we know of in June is Carol Smith, and hers is the 26th. Is anybody here else have a birthday in June? Okay, well, nobody's here except for Barbara Dean. Hey, Lisa, tell Barbara Dean to step to the door and we'll sing to her. Yeah. I should have said that first, huh? Here we go. Happy birthday to you. Happy birthday to you. Happy birthday, God bless you. Happy birthday to you. And many more. We have a couple of people on our prayer list for hospital stays. Rosemary Patterson is having surgery today, gallbladder surgery. And next Monday, Rebecca Earp is going to have valve replacement surgery. So if you would, remember them in your prayers. Also, Rudy Reeves just needs prayer, just constant prayer. And don't forget Pat Reed. I don't know if you noticed, but on the table, you've got flyers about the adult Bible school that's coming up. Brookie can sign you up back there, right back there, and just look at your calendar, and if you want to do that, it should be fun, and it's going to be like from 9 till 11 the week we're July 13, 14, and 15. Did you hear that? 9 to 11:30, July 13, 14, and 15. So it's right there on the flyer. Just sign up for that if you'd like. Also, we're going to go to the Barksdale Air Force Base in October. Now, for us to do that, we all have to have our paperwork signed up. They have to check everybody off because you all look like a bunch of terrorists to me. So, but you really cannot go unless you're signed up and they, go through the process. So even if you think you might not go ahead and sign up, because you can't, once the deadline passes, you can't go whether you want to or not. So you go ahead and sign up for the Barksdale Air Force Base tour. Remember, Amy was here a couple of months ago and talked to us. It was very interesting. Huh? I think yes. I think so, because she was in charge of the museum, and I'm pretty sure that's the major part of it, actually. So yeah. Also, on your table, there's little cards. I meant to bring mine up here. Husband, would you just hold it up? You don't, yeah. There's little note cards like that. Vanna David Dietzel over there. Don't do that, Dave. Anyway, the 13 youth and adults are going to be going to big stuff in Panama City Sunday. So we would love it if you would all write a little note of encouragement to them, just saying we're thinking about you, we're praying for you, have fun. We're proud of you because you're seeking God more. If you just write a little note and leave it on your table, and then we'll pick them up, and we're going to give them to them in a group, and let the youth leader read it to them. But that means a lot. I used to do that kind of thing, chaperone, and just to know that you got some real adults back there praying for you is encouraging. It's door prize time. Okay, we're gonna get Pat. I'm gonna tell you one thing, and hopefully I'll tell you this again at the end. When you leave, don't forget to leave your little name tag. Just stick it back in there. So that we can definitely enjoy knowing who is who at Young at Heart. Okay, let's see.
I tell you what, I'll let David draw them out, and as he tells Kate, I'll take care of it too.
Woohoo!
Maybe might be a more honest person. I'm just saying.
Go ahead, husband.
Started the joke. There was a preacher and a father.
Drum roll. Geneva Hensley.
I'll bring it to you.
Wait, let me see. This one says Geneva.
Joyce Baca. Ready, spaghetti? Let's do this thing. Also, we've got Judy Mayhew.
Okay.
There she is. Judy, I like this. She didn't fold hers. I'm not folding mine next time. Ta-da. Betty Smith. Where are you, Betty? There she is over there.
Yeah, I try to get one from this side next, so Lisa gets to run one. Can't get two from the same table, not at the same time.
Well, I need to.
You need two?
I need to. So, how about Nancy Sipe and Wanda Bennett?
Okay.
You did good.
Oh, wait, the middle tables. We got any more?
We're out of door prizes. I'm so sorry. And husband, it's your turn anyway.
Oh, okay.
Yeah, come on.
Okay. Well, Kay asked me to do this. She's a little unaccustomed to public speaking, and so I said, "Sure, I would be honored to do this." So today we have, and I'll introduce him a little more completely in just a few minutes. We have Mr. Doug Stinson, and he is going to speak to us today something about wills and estates and such, about that. And so I got to thinking, okay, what would be interesting to start with for someone that knows nothing about that? And so I just thought about, I've done some funerals, maybe I thought about my own funeral. I think I'm going to hire a ventriloquist. Think about it. I'll just leave it at there. Anyway, I'm just going to. Anyway, and I thought about, I saw this, a cartoon. A turkey is sitting in a lawyer's office. A turkey sitting in a lawyer's office, and he says, and lastly, Farmer Brown gets nothing if I die of suspicious circumstances. Anyway, Now, that was funny. Well, I just thought maybe you needed to see the turkey. But I also heard a story about a man in his 40s, Dan, never married, lived at home. His mother had died, and his father at this time was in very poor health and not expected to live much longer. But his father and Dan were very successful business people. And Dan had just kind of spent his life working in the family business so far, and he thought, well, you know, Dad's not long for this world, and by the way, I'm glad we have mostly women here, because this is a compliment to women in their estate planning. So Dan figured a while, he said, you know, he's worth about $40 million. And when he passes, that's for me. I'm the only child anyway. And he thought, you know, I should have a wife. I should get married. And so where do you meet? Anyway, he went to an investment club. And lo and behold, the first night there at the investment club, he sees this beautiful younger woman there in her mid-20s or so. And he said, you know, he's socially awkward, and he says, I'm just going to go for it. So he goes up to her and he says, hi, I'm Dan. You don't know me, but I'm looking for a wife, and I just wanted to tell you that I just look kind of ordinary now, but I'm about to come into about $40 million, and just thought she said, oh, really? And they began to visit a little bit, and he shared the whole story about his dad and ill health and all of that, and she seemed very interested, and she said, well, we'll talk again. Give me your business card. So he gives him the business card, and 2 weeks later, Dan had a new stepmother. See, women are just better at estate, you know, anyway. Anyway, that probably shouldn't have told that. In the woke society, I should, you know, don't send me any emails. My phone number is BR549, and you got to be old enough to remember what that meant there. But one more, I'm going to close. The last joke is, it's really a true story. Not really, but in Miss Chasson, she's a fifth grade teacher, and she's doing the math lesson, and she wants to give the kids a reading problem kind of thing and some practical experience. She said, okay, there's a man that passes away, and he has a will, and in his will, he gives his wife, a very wealthy man, $100 million to pass on. He gives his wife, wills to his wife, half of his estate. He wills to his son a fifth of his estate. He wills to his housekeeper, longtime housekeeper, a tenth of his estate, and the rest is given to charity. So tell us, what does each one get? And little Boudreaux shot his hand up, and she said, oh, not being the best student, but he raised his hand quickly and says, okay, well, how do you figure that? What does each one get? And little Boudreaux said, a lawyer. So that's it. But drum roll, boom, rim shot, we're through. But I did think seriously for a moment. Mr. Stinson is going to speak to us for a moment about a serious thing of our finances, but I'm going to kind of a devotion about what legacy do we want to leave a spiritual legacy? And not that money's not spiritual. I'm telling you, it is. But what do we want to leave spiritually, even if we don't have any finances? You know, I'm hoping my check to the funeral home bounces. You know, that's the legacy I hope to leave there. Just spend it all. But what do we want to leave? And I think there are just a couple of 2 or 3 things that I want to ask us to think about. What do we want to leave? I think it would be wise for us to leave a legacy of an obedient life. Joseph, you remember Joseph, read his story in Genesis. Joseph, as a young man, was immersed in dreams and visions, but you know, he was a dreamer. But when he was tested, when things got hard, Joseph remained faithful. Joseph remained obedient. He refused to get discouraged. His brothers sold him. You know the story. His brothers sold him into slavery. He worked his way up a little bit and got in trouble with Potiphar's wife when she lied about him, and just he was in and out of. But Joseph remained faithful and he was obedient and ended up second in command only to Pharaoh in Egypt. So he persevered. I read a statement, and it goes for the first and last point, but said, you know, by perseverance, even the snail made it to the ark. Anyway. Finally, anyway, but that I just threw that in there. He didn't allow bitterness to spring up. He persevered in obedience and eventually came out on top. The second thing I think we can all leave is spiritual children. We're going to have an opportunity in sometime during this program to write a note. Did you say that? Yeah, to write a note to the youths. Yeah, to write a note to the youth spiritual children. Encourage kids, not necessarily kids, but folks younger than I, and encourage them. And when I'm gone, I hope that when I'm gone, there'll be someone to say, he helped me spiritually. He encouraged me spiritually. Or someone, and I think of that song, it's an old gospel song now, Thank You for Giving to the Lord. And in that song, a guy dies just kind of uneventfully, but as he got to heaven, people lined up to say, thank you. I was a missionary. A missionary came to your church and you helped the missionary, and I got saved, and I'm here because of that. You know the story. YouTube, thank you, Ray Boltz, thank you for giving to the Lord. It'll make you cry. But that's the legacy. That's the legacy I want to leave, and I think we're called to leave that sort of legacy of spiritual children, to be spiritual fathers and mothers and grandfathers. I know for some of us with our own biological children, for some of us, they've already made up their minds. But I remember a man named Bob Goff in Pineville, Louisiana. Bob's son he was a retired colonel, Bob Goff, and he always, when he spoke just like this. You could just see he was addressing his troops always, his feet just like this. And anyway, but Bob's son did I say this already? His son was in prison. And Bob said, I long since cannot talk to my son. He said, but I pray that God will give me somebody's son to talk to. And Bob was a giant of the gospel to lead people to Christ. So that's our call as well. That just grab a kid in church sometime if you have to. And say, I want to talk to you, and adopt that child or your adult, and become a spiritual father or mother. And then the last thing, the legacy of keeping on, not quitting. I know that there are circumstances, and I'm experiencing some of those now that cause us to slow down, that cause us to have to back up a little bit, cause us, we can't do what we used to be able to do. But I think we can press on. And that's I would call that our a legacy, to know that, he didn't quit, she didn't quit. She kept on. And right now, you can think, in your mind, you're thinking of somebody that that you think, yeah, that was her, that was him. She never quit. She never quit loving and serving the Lord, even though everything else kind of slid away. So that's my 3-point sermon: obedience, spiritual children, and legacy of not quitting. Let's pray together just a moment. Heavenly Father, we've joined in your place, Lord, to enjoy each other's company, to be edified by a brief word, and certainly educated by a gentleman that knows some stuff. I pray, Lord, that you'd work on us and through us in this time. We pray your blessings on this group, and your blessings on the food when it's time for us to eat, Lord. And Father, may your Spirit move among us, we ask in Jesus' name. Amen. Now today, is it speaker time? Okay. Doug, are you ready? Okay, here's Doug Stinson. I suspect some of you, maybe all of you, know him. He's no stranger to Bossier Parish. He grew up here. He's presently a member of Cypress Baptist Church. He met his wife at Lauren. He met his wife Lauren in law school, and they're in Benton. They have 3 children: Ainsley 14, Tanner 10, and Hallie 8. He is a graduate of LSU, undergraduate degree there, Juris Doctorate, and his Bachelor of Civil Law degrees from Abair LSU Law Center. He received that and earned that in 2008. And then after law school, they moved back to Bossier Parish, and Doug began his legal career. He's began to work in Shreveport with Bradley Murchison, Kelly, and Shea, and he specialized in mineral law, oil and gas, and title examinations and civil litigation. And I was trying to put together, was that before or during Haynesville Shale? Okay, so you had plenty to do. Okay, making sure about all of that. So, and he was sworn in 2012, sworn in as an assistant district attorney in Bossier Parish, assigned to the juvenile division. Still continued to work part-time in the law practice in the partnership. And then in 2013, Doug opened his private law office in Benton, at the same office where his grandfather, Ford Stinson, and his father, Ford Stinson Jr., practiced law. So he's maintaining that string. He has been an attorney and here, and has been quite a mover and shaker in in Bossier Parish for several years. He's active in so many different things. And let me step away from the microphone. A word from our sponsor. There is going to be an opening for district judge, and Doug Stinson is either running or about to run for district judge, to submit his name for district judge. And if there are other candidates here today, please speak up. So, because this is an equal opportunity. Okay. Yeah, don't send me any emails about that either. So, and if there's other things that he would like to share, we'll give him that opportunity as we hear this morning Doug Stinson.
Good morning, everyone. I'm happy to be here. As I said, my name is Doug Stinson, and one thing, my wife and I, we actually met in undergrad at LSU, but she is from a town called Frogmore, Louisiana, and that's always a good conversation piece. Frogmore is near Faraday, and anyways, I dragged her back up here after I finished law school. She finished as a CPA. And after we had our second child, Tanner, she told me the last week of her maternity leave that she wasn't going back to work. And I said, well, that's a good idea, stay home for the first year, but you've got to do something. And so now she teaches at Providence Classical Academy in Bossier, and that's where our kids go to school. And then I've got to acknowledge the lawyer jokes. So growing up, my dad was an attorney, my grandfather was an attorney. I've got two older brothers that decided not to follow in the legal tradition, but growing up, we made lawyer jokes all the time to my dad, so it's kind of like you reap what you sow, right? And so, and then when you were speaking on spiritual legacies, it just reminded me, one of my favorite Proverbs is a good man leaves an inheritance for his children's children. And growing up, I always read that thinking that it meant money. And certainly, if you're able and capable, you want to leave your children and your grandchildren some sort of financial support. But as I've grown and heard stories about my grandfather and my dad, I know that it means way more than that, and the spiritual legacy, I think, is what we all should strive to leave for our kids and help them all grow up in a godly home and with, they may not accept it, but at least we tried. And that's what my wife and I are really trying to do with our children. I was asked to speak about wills and successions, and I'm going to try some of the legal terms. I think in law school, I decided that a lot of these terms are made up just so people have to hire lawyers because they don't know what a usufruct is, and they don't know what a executor is, and so the fact that we use big words makes us needed probably more than we actually are. But so we'll get started. I'm breaking it up into wills, and then we'll move into successions because typically the will comes first. In Louisiana, you don't have to have a will. If you die without a will, it's called an intestate succession. If you die with a will, it's called a testate succession. In Louisiana, I guess, why should you have a will? In a will, you can name who your executor, who your administrator is. You can also provide for what's called an independent administration, which with an independent administration, there's no bond required to be posted. Sometimes a bond is required to be posted, and that can be expensive for whoever's handling your estate. It's your will. You get to direct what happens to your property. I have people all the time come into my office and different sets of circumstances, second marriages, and and they're trying to navigate through that. And then also, some people have a child that maybe didn't make the best decisions, and it might not be fair to the ones that did, and they're always worried about offending someone. And what I tell them is, by the time they read this, you're gone. So you need to do what you want to do, and what you think is fair. And so, I mean, that's one big reason to have a will, is to make it easier on your heirs, and also to make sure that what you want to be done with your property is done. But again, if you don't have one, Louisiana law provides what is going to happen to your property. And so it's not the end of the world if you don't have one. In Louisiana, there are two types of wills: an allographic, and that's just a big word for handwritten will. Handwritten wills, people write out their wills all the time. There's some problems that can come with that, because it's very strict form requirements. And by form, it has to be entirely handwritten in the testator or testatrix, that's the person writing the will. It has to be entirely handwritten by that person. If someone else writes it and the testator, which is a male, testatrix is female, somebody else writes it and the testator signs, then it's not going to be valid. It has to be dated. If it's not dated, then it's not going to be valid. And there's no witness requirement on an allographic will. You can write one out, and I know from my dad telling me my grandfather had an allographic will, even though he was a lawyer. He just had a handwritten will. And the only difference between a handwritten will, well, not the only difference, but proving the will, you have to have an affidavit from two people when you submit that will to the court to probate it. You have to have an affidavit from two people saying that they knew your handwriting, and that the will was entirely written by the testator. Other requirements are you have to have mental capacity to execute a will, to draft a will. And when wills are contested, notarial wills or handwritten wills, one of the big reasons somebody might contest a will is to say that at the time the will was executed, the person did not have the mental capacity. Maybe they were suffering from some illness or cognitive dysfunction that would not allow them to sign a will. And that's litigated. You have to go to court, and you have to have medical testimony that says whether or not the person had the capacity to sign a will. And I've experienced people coming in my office, and it's always kind of heartbreaking to me. I have a client that his father and stepmother were, and y'all may know, they were killed in a tornado a few years ago that hit the Halton area. And there was one son that lived here and took care of them, and he brought me what he said was their last will and testament. And it was something they printed from the internet that had some pre-printed lines, and then it was like you fill in the blanks. And it was not notarized with two witnesses, so it would not meet the definition of a notarial will, so it would have had to meet the definition of a handwritten will. And it didn't work because it was not entirely written in their hand. And so what ended up happening was siblings that had kind of made some bad decisions ended up inheriting part of the estate, and there was no way around that. So I just say that to caution you all, if you do decide to get on the internet and print a form out, that Louisiana is very strict about the form requirements, and people get in trouble with that. And another thing that the will, if you handwrite your will, it has to be clear from reading it that you intend for that piece of paper to be your last will and testament. I had another succession where a man did not have, and I'll talk about this later as well, but a man did not have any children, never been married, both of his parents were deceased, and he had no siblings. And so they found a letter that was written to his girlfriend at the time, and there were some questions as to whether the girlfriend may have been the lady from the financial meeting as far as why she had taken an interest in this man. And well, there was a letter where he wrote to this lady and said, "This is what I want you to do with my stuff when I'm dead. You know, you can keep the coins." He had a big coin collection, a big gold collection. He said, "You can keep the coins. I want you to take the gold to this place in Shreveport and sell it." And he listed all these instructions to her. And well, she took that letter to the court to try to get them to probate it as a will. Well, I had a cousin that was good friends with the person that passed away. He'd stayed in contact with them, and he said, "This isn't right." And so we contested the will, and we did it on two grounds. One, the will was not dated, or the letter was not dated. And then two, I argued that the person did not intend for this letter to be his last will and testament, because nowhere in it did he say, "This is my last will and testament." And to me, it was just a letter of instructions. The court ultimately didn't rule on whether or not it showed the intent to be the last will and testament, but the court did rule that it was invalid because it was not dated. And so ultimately, the first cousins inherited this man's property. So I tell you that if you do your handwritten will, you just need to be careful, because there are very strict form requirements on that. And if you do one, maybe get an attorney to look at it and say, will this hold up? Because I would hate for someone to do that and it not hold up. The other form, and probably the most common and safest, is a notarial testament. And what that is just, it's a will it can be typed, it can be handwritten, and it can be handwritten, but it's got to be notarized in front of two witnesses. And there's a certain requirement in a notarial testament called an attestation clause. And that clause basically says that the testator appeared before the two witnesses and the notary and declared that this was his or her last will and testament. And the bottom of every page has to be signed. On mine, the ones I prepare for my clients, I put the date and a signature line on the bottom of every page. And then the last page, on mine, they actually sign 3 times. But the big thing is it has to be notarized in front of 2 witnesses. Let's see. As far as who can serve as, and there are different types of notarial wills. I'm really just talking about the most basic one. If there are certain requirements, if the testator is blind or deaf or physically unable to sign, there's certain requirements. I don't see those too often, so I'm mainly just talking about the ones that I do on a regular basis. The 2 witnesses to a will, if you are an heir or a legatee in the will, a legatee is someone that the testator says, "This is who I want to inherit some of my property." You do not need to be a witness, nor does the legatee or a spouse of a legatee need to be a witness, because if so, then that legacy that's left to the child or to the heir is going to be invalid. And so an example of that would be a father makes a will to his 3 sons, and one of the sons' wives signs as a witness. Well, whatever he left to the son whose wife signed as a witness, that legacy would be invalid. Now, that son might still inherit. We'll get to that in a little while, but the safest thing is just to find witnesses that are in no way related. And I'm up in Benton. My office is right across from the school board. I do not have a secretary or a paralegal. It's just me. And so there's some ladies at the school board office that are always good to me. They'll come across and sign as witnesses, or sometimes we go down to First National Bank where I have my firm banking account, and they're always really good to me. But the best idea is to not have anybody in any way related serving as the witnesses. As a witness, you could be 16 years or older. It's not an 18 requirement, but I typically, just to play it safe and avoid the chance of anybody contesting it, I typically make sure that they're 18 years of age. As far as if you have a will and you want to get rid of it or you want to change it, revocation, I'm on the second page. One way to get rid of a will is just to destroy it. Tear it up, burn it, throw it away, but make sure it's destroyed so that if that's not what you want to happen anymore, people change their wills all the time. One way is to physically destroy it. Another way is to declare in one of the forms required that you revoked your prior will and testament. And all of the wills and testaments that I do at my office, one of the first lines says, now appearing is so-and-so who revokes all prior wills and testaments. And they may not even have one, but I put that in there just to make sure that there's no question. Or you can identify and clearly revoke the testament in a writing entirely written and signed. And this one, a date is not actually required, but the safest thing is probably just to destroy it. And that way no one can find it and try to present it to a court to probate it. To modify a will, you can declare that a legacy is revoked, which is the same form requirement as a notarial will or a handwritten will. Let me go back, I'm sorry. On the handwritten wills, another thing that happens is people will handwrite a will, and then a few years later, they'll get that same handwritten will, and after they sign their name, they'll add in something. Well, anything after the signature is not taken into account. And so when people do that, the postscript, by the way, I now want so-and-so to inherit my wedding ring. That's not going to be a valid legacy to that person because it came after you signed the handwritten will. So wanted to make sure I said that. Another way to modify a will is you make a subsequent testamentary in your will. You make a subsequent incompatible donation. So let's say you leave, I'm trying to think of a good example. This doesn't come up often, but if you said, I leave all of my property to my son, and then the next paragraph says, I leave my 12-gauge shotgun to my other son, well, that's incompatible, and so the 12-gauge shotgun is going to go to the other son. That doesn't happen too often. I don't see that, but that's another way you can modify a will. Also, if you make your will and you leave certain things in your will to certain people, but during your lifetime, you make it's called an inter vivos, that's during your lifetime, you make a donation of that to someone else, then that's a modification of your will because you've changed your intent and manually given someone a gun or a ring or a piece of jewelry, something like that. And if once you pass away, the person that was left the ring, they may say, well, where's my ring? And you would have to prove, or the person that received the ring would have to prove that they received it during the person's lifetime. And so that's another way to modify a will. If you have a will and then you get divorced and you don't redo your will, then Louisiana law provides that a legacy to a divorced spouse is not going to be valid unless in your will you said that I want this person to receive this property regardless of whether or not we divorce. And so I have seen some wills where the person had a will and left some property to a spouse and they divorced, and then the kids bring the will and say, well, they divorced 10 years ago, and the divorced spouse is not going to inherit in that situation. Louisiana, one thing that's unique to Louisiana, and I'm sure y'all have all heard about it, is forced heirship. And I know just from talking to my dad that forced heirship, when he was in law school and started practicing law, is way different than what it is now. There was a big change in the early 90s that they were trying to get away from forced heirship law. And so now forced heirship, a person is considered to be a forced heir if they are a descendant of the first degree, so a child of the person that passed away, the decedent, if they are descendant of the first degree and they are 23 years of age or younger. And so in my instance, I have 3 kids all under the age of 23. If I passed away, I would have 3 forced heirs. And what that means is if I had a will that said I leave all of my property to my wife, forced heirship would kick in. I would not be able to do that because Louisiana has forced heirship. It's forced that some of my property goes to my 3 children because they're under the age of 23. And since I have 3, the forced portion of my estate, and that's the amount that has to go to my children, would be 1/2 of my estate would have to go to my 3 children. And if you only have 1 forced heir, the forced portion is 1/4 of the estate. And so it's 23 years of age or younger and a descendant of the first degree, or I hope this does not happen, but if it does, let's say I have a grandchild, and my child is 22 years of age, and she passes away, and her grandchild is obviously under the age of 23. Well, the grandchild would be a forced heir under what's called representation. She would represent her mother, my daughter, who passed away before me, and inherit a 1/4 portion of my estate. And I hope that makes sense. But so it's descendants of the first degree or their descendants, but they have to all be under the age of 23 at the time of death. The other forced heirship that comes up is if you have a descendant of the first degree or a grandchild of the first degree, or grandchild that is physically or mentally unable to take care of their person or their estate. And I actually had a case where a father was always changing his will, and his last will left all the property to his girlfriend, and he was in his 70s. And the son, right before the father passed away, had gotten in an accident and was paralyzed. And so the son was devastated that he was left out of the will, and I just told him, I said, well, there's nothing that I can do about that he made this will, and it's the last one that we know of, so the girlfriend's going to inherit. However, I filed something with the court in Shreveport that said he was a forced heir, and I got a doctor to sign a medical note saying that he would be unable to take care of his person due to his paralysis. And so I at least got him 1/4 of the estate where he would not have received anything, because even though he was over the age of 23, he qualified as a forced heir. And it's at the time of death of the decedent when forced heirship is determined. And so he had been paralyzed before his father passed away, so he met the definition of a forced heir. The other possibility is if a child, I just need to read it to make sure. This includes descendants who at the time of death of the decedent have inherited incurable disease or condition that may render them incapable of caring for their person or estate in the future. So that one instance, if you have a descendant of the first degree that has some sort of disease or illness that in the future may render them incapable, and for the life of me, I can't come up with an example for y'all, but I'm sure y'all probably can come up with something, that if in the future it would render them incapable, then they would qualify as a forced heir. Now, they would have to present some sort of medical testimony or evidence to prove that, but that would make them a forced heir. And the only thing that in my practice, I don't see it a lot, because most of the successions I do are people that are, higher up in age, and their kids are over the age of 23, and most of them do not have children that are forced heirs. And so it used to be a big deal in Louisiana. Now it doesn't come up as much, but it's still something that is taken into account. And the reason for forced heirship is Louisiana has an interest in making sure that children are not left destitute without anything to help them take care of themselves, and also the physically and mentally infirm. And that's the reasoning behind forced heirship. Does anybody have any questions about forced heirship? I want to make sure, hopefully I explained it fairly well. I get this question a lot. After I do a testament or a will for someone, they'll say, now, do we record this at the courthouse? And my answer is always no, because you have to, when you pass away, your executor or executrix is going to have to take the original will and file what's called a petition to probate the will, and you have to attach the original will to that petition. And if you filed it, the clerk's office is not going to give it back to you once you file it. I always tell people to put it in a safety deposit box or a safe in their home, fireproof safe or something like that. And I also tell them to let your executor know that you have a will, let them know where it is, and your children, if some people don't trust their kids that I deal with, but I say, tell someone that you trust that you have a will and tell them where it is in case anything ever happens to you. What you can do, the Secretary of State in Louisiana has a registry, and you can sign up and tell the Secretary of State that puts the public on notice that you have a will and where it's recorded. And that information, is my understanding, is private. And the only way they'll let that out is if they are presented with a death certificate, affidavit of death and heirship. Somebody signs an affidavit saying that I knew this person and they were married and they had this many kids and that they died on this date. Then the Secretary of State will let that information out. And then it says, or other satisfactory evidence of the death of the testator. What that might be, I don't know. That's kind of a vague term, but I don't necessarily recommend doing that, but it's certainly something you can do if you want to make sure that someone will know that you have a will. So now that we've kind of gone through the wills and testaments, and I'll just tell you, most of the wills I do are not complicated. Most of them are a husband and wife, and older than me. Usually they're in their 50s or 60s or 70s, and they've never done a will, which I found is not uncommon. And most of them say, if I die, I leave all of my property to my wife. And if in the event she predeceases me, then all the property goes to my children in this, in equal shares. And that's, most of the wills I do are along those lines. If they're split families, sometimes they can get a little more complicated, but it doesn't have to be super complicated. And in the wills I do, I provide for an independent administration, which makes it easier on the person that's administering your estate. It does not require a bond, and they can sell and mortgage and lease property as the succession representative without court approval. If it's not provided for, if an independent administration is not provided for, every time the administrator wants to do something, they've got to go to court and get the judge to say, okay, I approve of that, and and give the other heirs an opportunity to object. So that's one thing that's important in the wills that I do for people. And then naming who the executor is another thing. But they don't have to be complicated. And if there's certain items you want going to certain people, you can put that in there as well. But that's the majority of the wills I do, is I leave everything to my spouse, and then in the event a spouse predeceases me, it goes to all of my children, and the spouse's will says the exact same thing. So ultimately, the kids end up with everything eventually. So now we're to the point where it's time for a succession. So the testator has drafted a will and has passed away. And so what happens at that point? A succession in Louisiana is it's the transmission of the estate. The estate is property, rights, obligations, which includes debts. That comprises the estate. Well, a succession is the transmission of that estate to the deceased person's successors, and it happens at the moment of death. And so, just for an example, and I don't even know what my dad's will says, but I'd like to think I'm in it. But if he passed away today, and I'm in his will, well, at the second that he passed away, his estate would be transferred partially to me. I've got 2 older brothers, and I imagine they're in the will too. But at the second he passes away, his estate would transfer to me. However, judicially speaking and legally speaking, my rights would not be recognized until a succession is filed and there's a judgment from a court, a judgment of possession. And then that judgment of possession recognizes the fact that I have inherited property from my father. And so a lot of people think, well, they had a will and I'm the heir, so I own all this. And I say, well, that's correct, you do. However, you're not going to be able to do anything with that house until you get a judgment of possession, because without the judgment, there's going to be a break in the chain of title. Nobody's ever going to be able to get a loan from a mortgage company to buy the house from you. And same thing with banks, is if the person passes away and there's nobody else on the account, a bank, if they find out a person passes away, they'll freeze the account. And if you say, well, I've got a will, they'll say, well, I don't know that that's the last will that the person did, and so I need a judgment. And then you get a judgment of possession that says so-and-so inherits the house and the bank accounts, and then you take that to the bank and they'll actually talk to you. And so that's what succession is, the transmission of the estate at the moment of the decedent's death. And how that happens is called season. And that's just a Louisiana term. I think it's unique to Louisiana, where successors are seized with or acquire ownership at the instant of the death of the person. And again, at some point, it's advisable to get a judgment of possession. The complexity of a succession, it just depends on different factors, mainly whether or not there's a lot of debt, whether or not maybe the person was involved in a lawsuit at the time that they passed away, or another reason, I'm trying to think of, if a person has a lot of income coming in. I had a succession where a lady had mineral rights all over the country, and the son had no idea what she owned. And so we filed to have him named as the administrator, because we were trying to figure out what all this lady owned when she passed away. And the way we were figuring that out was by the checks coming in. And he would open the checks, and then we would write to those companies and say, she's passed away, can you tell us what interest she owned? And that way we could include it all in the succession paperwork. Most of the successions I do, even if they have a will that names an administrator or an executor, most of the successions I do and file with the court, we do not do an administration. Most of them, the estates are relatively free from debt. There may be a little credit card debt, or maybe some medical bills, or possibly a little bit left on the mortgage, but the assets exceed the debt. And there's no need to place it under administration. And we just file the will, or if it's not a will, we file a petition asking to place the heirs in possession of the property. And again, most of the ones I do are fairly simple. Once I get everything typed up and drafted, we file it, and usually the judgment is signed within 1 or 2 days, and it's over with. And so, and then when should a succession be opened? So if you have a loved one that passes away, the idea is as soon as practicable. Now, I have people call me the day someone passes away and say, we got to do a succession. And I tell them, get through the funeral, and, don't worry yourself with this. We'll get to that, in the next week or 2 or a month, but don't feel like it's something you've got to do this very second. But you don't want to wait too long, because if you wait too long, I have people come in all the time that say, I own this property here in Bossier. And I started asking questions. Well, how do you own it? Well, it was my great-grandfather's property. And I own, 1/10 interest. And I said, well, so I started saying, well, was there a succession done on your great-grandfather? No. Was there one done on your grandfather? No. And then it just gets very, very complicated. So the sooner you do one, the less complicated it is for others down the road. If you are in need of surviving spouse, let's say their spouse passes away and they're in need of money to help pay for medical bills or the funeral, you can do a surviving spouse affidavit, and that's Louisiana Revised Statute 9:1513, which allows the surviving spouse to withdraw up to $10,000 from a financial account. And that you can do that before the succession is done. That's just something that might come up. There are two types of successions, going back to whether or not you have a will or not. Intestate is without a will. Testate is with a will. If you die intestate without a will, Louisiana law determines what's going to happen to your property. Community property is property acquired during the marriage. There are some exceptions, property acquired by donation or inheritance to a single spouse. So if my wife inherits from her parents, that's her separate property, even though she inherited it while we're married. That's not going to be community property. That's an exception. Fruits of separate property are considered community property, and this came up during the Haynesville Shell, where people started, they had separate property that they inherited, and then they either got bonus money or, royalty money. Well, that's considered fruits of the separate property. Well, that income is community property. And then a joint donation. So let's just say my mother-in-law donates to my wife and me, a car. That would be community property because she donated it to both of us. Now, if she donated it to just my wife, then it's separate property. And it can get more complicated than that. But does anybody have any questions about anything we've gone over so far? Okay. Yes, ma'am.
When you talked about the banks, freezing everything, what do you have, like your daughter also on your account?
I think that
account open?
I think it will. Different banks I've found operate differently than the major national banks are usually a little more difficult to work with, and they have to call legal, and you have to sit there for a long time. But if you name someone on your account, they should be able to access the funds. That's another thing is banks, if you take a power of attorney to a bank and say, I've got power of attorney, I want to withdraw funds, they're going to tell you to take a hike unless your name is on the account. And so I often have clients that I tell, if you're worried about how things are going to be paid for if something happens to you, maybe add a child to be able to sign on the account. And then I tell them if you don't trust them, then don't do that. But and most of the clients I have, have at least one child that they say, we'll take them to the bank and add them to the account. So is that?
I did not realize until very recently that a power of attorney is null and void at the time of death.
Oh, yes, ma'am. Yeah.
So a lot of people did not know that.
Right. Yep. As soon as the person passes away, that power of attorney is no longer valid. So I'm glad you mentioned that. So intestate without a will, intestate succession, it depends on whether it's community property or separate property. Community property, the spouse of the decedent, the person that passed away, the spouse is immediately going to inherit her 1/2 of the community property, and then it immediately becomes her separate property. Now, what happens to the decedent's half is that spouse will have what's called a usufruct, and that's a good Louisiana term, and they'll have the usufruct over it, which means they can use it for the remainder of their life or until they remarry. And then once they remarry, it goes to the other heirs. And the easiest example is married couple, they have 2 kids. One of the couple passes away. The wife inherits her half of the community property. The other half, she has a use of it, but the children would be called the naked owners. That means they own the property, but they really have no use of it. They can't use it as long as the usufruct still has use of it. And a lot of times that's not I'm doing a succession right now where the person didn't have a will and the kids are going to be the naked owners of the property and the wife is going to have the use of it. But you can imagine that there are going to be times where that would create some difficulty, and that's why if you have a will and you just leave it all to your spouse, it could make it easier. But it's not the end of the world if everybody gets along. And this client I have, she said that they went and saw a different lawyer, and he said, well, if everybody gets along, you don't need a will, which what he said is correct. You don't. But would it have been easier if he had a will? Yeah, it would have been easier. But I mean, what he told her was correct. Louisiana law will do exactly what it is y'all want to do anyways. So community property, surviving spouse gets her half, and the other half goes to the other decedent's heirs. Separate property goes to the other heirs of the decedent. And Louisiana, it sets an order, and the first class of people, they inherit to the exclusion of the lower classes. And the first class is descendants, so children or children's children. That's the first class. And so if I pass away and I did not have a will, my kids, my descendants, would inherit my half of the property, subject to the usufruct of my wife. The next class is if you die without descendants, then your parents and siblings will inherit. And there are many different scenarios. If you only have parents, the parents would inherit. If you only have siblings, they'll inherit. If you have parents and siblings, then the siblings are the naked owners, and the parents have the usufruct of the property. That doesn't happen too often that I've seen, but that's the order of progression. The third person or group of people would be the surviving spouse. So if you pass away without a will, and you do not have children, and you do not have siblings or parents still living, then your surviving spouse will inherit all of your property. If there's no surviving spouse, more remote ascendants, grandparents, aunts, uncles, they're the next group of people that will inherit. And if you don't have more remote ascendants, the grandparents, aunts, and uncles, then the more remote collaterals, which is cousins, second cousins, they would inherit. And I've never in my wildest dreams thought I would see a case or handle a case where more remote collaterals inherited until I had that case I told you all about earlier, where we had cousins that ended up inheriting the property. So it does happen. And then last but not least is if you don't have any of those, the state of Louisiana will be glad to inherit your property. So, and I get that a lot where people are like, I don't want my property going to the state. And I start asking questions, well, do you have family? And they say yes. And I say, well, then it's not going to. That doesn't happen very often, but it certainly can. And again, the most favored class inherits to the exclusion of the other classes. Now, a testate succession, when you die with a will, there are different ways you can leave property in a will. A universal legacy is where you say, I leave all of my property to so-and-so. That's universal, covers everything. A general legacy is a fraction, like I leave one half to A and one half to B. And a particular legacy is, well, it's neither universal or general, but it's typically, I leave my wedding ring to my daughter. That's a particular legacy. Now, what happens if you have a will and someone that you leave property to predeceases you? That's called a lapsed legacy. And a legatee the person that's given the property in the will dies before the testator, or the legacy is renounced, or the legacy is declared invalid, then what happens when that occurs is called accretion. And the will can say, I leave my wedding ring to my daughter. In the event my daughter predeceases me, then I want the wedding ring to go to my niece. Well, that you can do that in your will. If the will does not have a governing provision as to what happens if the legatee, the person that's to receive the property, predeceases you, then Louisiana law provides what's going to happen. And a lapsed legacy, if you don't have a governing provision, like I said, ring to my niece, a lapsed legacy goes to the descendants of the legatee. If the legatee is the testator, the person with writing the will, if the legatee is the testator's child or sibling. And so in that instance, if the wedding ring goes to the daughter predeceases the testator, then the daughter's kids would inherit the ring. And that's if there's no governing provision. If you have a joint legacy, and this is where, like if you say, I give all of my property to A and B, and A dies before B, well, if there's no governing provision of what happens if A dies before B, then B is going to inherit all of it. And so most of the wills I do say, I leave all of my property to my 2 kids. Well, I'll say not 2 kids. I leave all of my property to my 2 friends, Mark and Susan. Mark passes away first, then Susan would inherit everything. Unless you said, if Mark predeceases me, then I want this person to inherit. That would be a governing provision in the will. So that's a kind of a nuance that some people maybe could mess up on if they were doing their own will. And that's what I always ask, okay, well, if they predecease you, what do you want to happen to that property? And they usually say, well, I want it to go to my grandchildren. And that's what would happen anyways, but I usually spell it out in the will. A particular or general legacy, when those legacies lapse, they go to the successor who under the will would have received the thing if the legacy had not been made. Now, what that means is you leave the wedding ring to your daughter. Your daughter predeceases you without any children, and then at the end of your will, you say, I leave all of the rest of my property to my 2 other daughters. Well, that would not work, I'm sorry. You leave a wedding ring to your friend. Your friend predeceases you, and you don't have a governing provision of what happens to it. And then at the end of your will, you say, I leave all the rest of my property to my children. Well, then your children would inherit the wedding ring. Does that make sense? Okay. And a lapsed legacy, which is not disposed of under the rules I just discussed, goes to the universal legatees, the ones that you say, I leave all the rest, or I leave all the rest of my property to this person. It'll eventually go to them. Any portion of a person's estate that is not disposed of under the rules that we just talked about, under the accretion rules, then they're going to follow the rules we talked about in an intestate succession, which would mean descendants inherit first, parents or siblings are second, and then surviving spouses third, more remote ascendants, and then more remote collaterals. So if there's something in the will that ends up not going to someone, then it's going to follow Louisiana law as if you died without a will. One thing Louisiana has is representation, and they tell you in law school it's a fiction of the law. And so representation, all it means is if, let's say I pass away before my father, then my children would represent me in my father's succession, and they would inherit my share. So my dad has me and my 2 older brothers, and again, I'm just using this easiest way to explain it. I don't know what it actually says, but let's say he has a will and it says, I leave all of my property to my 3 sons in equal shares. So we're each to get a 1/3 share. well, I pass away before my dad. Well, my 3 children would represent me in his succession, and they would inherit my 1/3 share. And so they would each end up with a 1/9 share each. Their 3 1/9s would equal my 1/3, and then my brothers would inherit their 1/3 each. And that's Louisiana law provides for that, and that's permitted only in the descending and collateral lines. So at some point, if you get to, like, if your parents were to inherit your estate, representation's not going to take place. But that doesn't happen often. And when you get to some of these scenarios, even though I learned it in law school, I get some of these scenarios and I'm like, I gotta refresh my memory on how this is all going to shake out. And like the client I had who was a cousin, he started telling me this, and I said, well, I think this is how it's going to go, but I need to look at the civil code and make sure. And then as far as the procedural issues, that's the law on successions. Now, what actually is a succession, or what do I mean by that? When someone says, okay, well, so-and-so died, you need to file a succession. Well, what they mean is you need to file a petition with the court and either probate the will, attach the original will, or if there was no will, you need to file a petition to ask that the heirs be placed in possession of the property. Louisiana does have something called small successions by affidavit, and if the value of the estate is $125,000 or less, you can do it by affidavit, and there's certain requirements that you have to meet. And every time I do one, I have to look them up to make sure that it's done correctly. And I've kind of listed a few of the requirements, but it has to be signed by a surviving spouse and at least one heir. If all the heirs don't sign it, then you've got to certify under penalty of perjury that you gave all the other heirs an opportunity to object. That's something that Louisiana started, and it started at $50,000, and then they raised it to $75,000, and they just recently raised it to $125,000. Now, and you can do that if you passed away without a will. If you passed away with a will and your estate's worth less than $125,000, you can still do an affidavit by small succession, but you can't if you own immovable property. So only if no immovable property, and the probate of the testament would have the same effect as if the deceased died intestate. I don't do a lot of those, maybe one or two a year, because most of the people I do successions for actually own immovable property. And so then you just file a petition, and again, most of the successions I do they're not contested. Everybody agrees that, who's going to inherit the property. And I file a petition. With the petition, I file an affidavit of death, domicile, and heirship. And in that affidavit of death, domicile, and heirship, I spell out the person's family history, that they were born on such and such date, they were married however many times, they had this many kids, and these are their names and dates of birth. They did not adopt or have any other children, and that none of the children are forced heirs. Or if there is a forced heir, I'll spell that out in the affidavit. And that has to be signed by 2 people that knew the decedent and can sign an affidavit saying, I knew this person and this is true and correct. Another thing, you have to have a sworn descriptive list of assets. So you have to list out all the assets, and the biggest ones you want to list are the property, the home, immovable property, because that judgment of possession is eventually going to act like a deed. It's going to fill in the chain of title. You also want to list bank accounts, so when you get that judgment of possession, it's going to have the bank account listed, and you can take it to the bank and say, here's the judgment, here's the account, I'm the owner. And you're supposed to list a fair market value of all the assets, because Louisiana no longer has an estate tax, but there is a federal estate tax, and I think it's at 14 million, where if your estate's worth over 14 million, you've got to pay a federal inheritance tax or estate tax. I've never done a succession. I mean, I've been surprised a few times, just some people that have come in and very modest people, and then, we add up the sworn detailed descriptive list, and they have estates in the millions, but 2 to 3 million, but I've never gotten close to the 14 million. So, but you do have to list the fair market value. And that's most of the successions I do. We file all that, and within 2 days, one of our judges, like Judge Self or Judge Smith, he goes to church here, I think, and Judge Pittard, they'll sign it, and it's actually now done all electronically. So we file it, and then I'll check the clerk's site a couple of days later, and I'll see that they've e-signed it, and then it's finished. If you have to do an administration, that's a little different. You just file the petition, and if there's a will that names the administrator, you file the petition and you ask the court to appoint so-and-so as the administrator. And then you get letters of administration issued by the clerk's office, and those letters of administration allow you to take legal action for the estate until you ultimately get that judgment of possession. And again, you may have to post a bond if it's especially if it's a contested succession. And the purpose of the bond is to, if you swindle assets from the estate, that the other heirs will be protected by that. I'm trying to think if, and again, the independent administration is something that makes it a lot easier for whoever's handling your estate. And if you die without a will, you can still get an independent administration, but all of the intestate successors, all of the heirs have to agree to allow there to be an independent administration. And you can imagine that there probably are going to be times where they're not all going to agree. Yes, ma'am. If it's not finalized, it has not been signed. Finalized and it hasn't met the form requirements, where it hasn't been signed on the last page, then it's not going to be considered a valid will. If it has been finalized and it's something you want to change and you don't, and somebody finds it and they probate it, then that's going to be your will. Does that answer your question? Okay. Yes, ma'am. It needs to be changed or done away with. Is that what you asked? Well, the only way to revoke a will, there are 3 ways, the easiest way is you just destroy it. Just tear it. Where did you filed it at the clerk's office? Okay. Well, then you would need to draft something before a notary and 2 witnesses that says that I revoke my prior testament. And if it's recorded somewhere, you might want to reference the recording number, and that way it's clear that you've revoked it. So, okay. That's, as far as wills and successions, that's kind of a general explanation. Again, yes, ma'am. Yes. Usufruct. The spouse. So if the spouse wants to sell the house, she can, and the proceeds, she would have use of the proceeds. However, the naked owners are going to have to sign off on the deed as well. So the spouse gets to use the proceeds of whatever's sold. However, on immovable property, the naked owners have to sign the deed as well. Right. Right. So all of the person's succession estate. So that's, and you asking that question, when you inherit property, you inherit all the assets, but you also agree to inherit all the debt. And so I've had one case where a person came in and said, I'm the heir of this property, and it was, you know, a piece of land that may have been worth $20,000, but the debt was, you know, enormous. And I said, well, if you want this piece of property, then you're agreeing to take on all this debt. And they were like, well, I don't want to do that. And so they ended up renouncing the succession. And they said, I am an heir, but I'm renouncing my rights to it. And so that's another thing is your heirs, if they choose to accept your estate, then they're accepting the assets and the debt. So a lot of successions I do, there'll be some credit card debt left behind. And one thing that I've found is credit card companies, for whatever reason, are willing to write off sometimes all of the credit card debt, or you can negotiate it down. And I help some of my clients with that. And a few times they've just said, well, we've just closed the account. You know, everything's good. Sometimes they'll get a demand letter, and I'll say, you know, we all negotiate and accept half of the amount. And I've had one where my fee was paid for 2 times over by the amount of money that they saved negotiating with the credit card companies. So that is something that can take place. They don't have to do it, but I've found that most of the time they're more than willing to. They just want to get something, I guess. Yes, ma'am. And that's not Louisiana law, that's more banking regulations. That's what I've found in practicing law here, is that the banks have their own set of rules. And again, you take a power of attorney that says I give them the right to draw a check from my bank account. The bank's going to say, I don't care what that says unless their name's on the account. And I get the reason behind it is they don't know if that's the last power of attorney that's ever been, you know, signed or granted. And right, but so yes, ma'am. What I tell clients is to contact your bank, and most of the banks say that the bank account owner has to come into the bank and fill out a form specific to that bank and add the person, and that person's got to be there, and they've got to get their ID, and they've got to get their signature so they can match it. But yes, ma'am, that's what everybody else knows. Yes, ma'am. Yeah, that's correct. So, does anybody have any other questions, or if I missed something that y'all know that I didn't cover? So, well, I appreciate it, and I am happy to be here. And so I work at the DA's office, and that takes a lot of my time. I prosecute cases anywhere from misdemeanors all the way up to the worst felonies you can think of. And so I'm not in my office full time, but a lot of the work I do in my private office in Benton is successions and wills. And so I'm happy to speak to y'all about it, and thanks for having me.
Thank you, Doug, so much for coming and sharing that lot of valuable information, and obviously timely for all of us. So let's bow our heads and pray, please. Father God, we just thank you so much for your goodness to us. And we thank you, Lord, for the food that's been prepared for us and for the hands that prepared it. We thank you for this beautiful day, and we thank you that Doug was willing to come and share his wealth of knowledge with us. Father, help us as we live our life to make sure and leave a legacy that would honor you in every way. Father, help us to live our lives every day so that we not only show your glory and your majesty, but that we lead others to know you. We pray these things in Jesus' name. Amen.